presenter here for Hope or here for HASP. Like I said, this is his fourth presentation. So I think he knows what he's talking about, and hopefully we'll all enjoy what he has to say. Thank you. Go ahead.
Thanks. Thanks for the introduction, Lynn, and it's a pleasure to be back making a presentation for HASP. And for those of you who were at my last presentation where I was 15 minutes late, I apologize again for that, but I served my HASP detention and they allowed me to come back. So this is an area I'm excited to try to present to you today regarding the rules of evidence. I'm trying to get my there we go. Rules of evidence. Now, many of you may be like me, that your first introduction to the rules of evidence was on the old Perry Mason show, if you're old enough to remember that, or young enough to stay up late enough to watch it on TV these days. And there would always be some point during the trial in the court where Perry Mason would try something and poor Mr. Berger would jump up and shout, "I object, Your Honor, it's incompetent, it's immaterial, it's irrelevant. Mr. Mason's trying to make a circus out of the courtroom." You know, I didn't understand what incompetent, immaterial, and irrelevant meant, but it sounded bad. And it would always be the case, however, where Mr. Mason would say, "Well, if the court will grant me some leeway, I intend to show that that nervous-looking guy in the second row is really the one who murdered the person here and not my client." And the judge would always let him have his way. Now, I've learned since then that Mr. Berger was probably right about his objections, but it did him little good in the TV show. So I want to try to condense in this presentation a couple semesters on the law of evidence that I took in law school and 40 years of experience as a trial attorney, as a judge, which obviously is a daunting task, but we'll try to get through it. I'm available for your questions at the conclusion or as we go forward here. So, the rules of evidence in the courtroom. All trials involve two phases. Whether it's a criminal trial or it's a civil trial, there's basically two parts to a trial. The first part is the presentation of evidence, which is the fact finding. And then after all of the evidence has been presented, either the judge will then make his findings of fact and apply those facts to the law, or in a jury situation, the judge will instruct the jury as to what the law is, tell them that they are the sole determinants of the facts, and whatever the facts are that they decide on and the law that's involved, that's how the verdict is arrived at. Now, the facts of a case are introduced in one of three ways, either by stipulation or agreement to the parties. It may be that at the start of the case, the lawyers will say, "Your Honor, we stipulate to this fact and this fact and this fact, and we won't be presenting evidence on that." And that's fine as long as both sides agree that that's the way it's going to be presented. That's fine. There's also, good grief, there's also judicial notice, where the court itself can simply take notice of the fact that may be relevant to the case without requiring proof. And I'll cover that a little bit more as we go along. But in most cases, the facts of the case are determined by the evidence that's introduced at the trial, which consists, the evidence would either consist of the testimony of a witness or documents that are admitted as exhibits, documents like photos or contracts or whatever the case may be. Now, the law of evidence is like the law of contract or torts or any of the substantive law. It was developed over the centuries by court decisions that formed the basis of the common law. And it's been the case that the common law tradition of evidence, and some of it still exists, things like lawyer-client privilege is still a matter of common law. But in most cases, the common law has been codified by the courts into the rules of evidence. And in 1978, the Michigan Supreme Court adopted the Michigan Rules of Evidence, which have been modified somewhat. But this is still judge-made law, like the common law, though the legislature can also pass statutes that have an impact on the law of evidence. Because the law of evidence involves court procedure rather than substantive law, the legislative enactments are, if they are in conflict with the rules of evidence developed by the courts, the rules of evidence take precedence or priority. But for the most part, the statutory laws, and we'll cover some of those going forward, are equally valid as long as they do not conflict with the procedural rules developed by the Supreme Court that we follow in all of the trial courts. So some examples of legislative enactments that involve the rules of evidence are so-called rape shield laws, where the past sexual history of a rape victim are not admissible in evidence unless it involves activity with the defendant or other very limited circumstances. The legislature has also passed an enactment where the prosecutor would be allowed to produce evidence of prior assaultive conduct by a defendant as a means of trying to prove their case in a domestic assault situation. And again, it does not conflict, though it comes close to conflicting with the rules that we have regarding character evidence, but at this point it's a statutory enactment that the courts follow, even though it came from the legislature. And as I mentioned, one way of evidence being produced is through judicial notice, where neither side needs to produce evidence. So the judges can take judicial notice, which makes it good evidence, of either adjudicative facts or notice of the law. So with notice of the law, I don't need to have a party prove what the law is. They don't need to have a certified copy of the statute in question. That's a fact of the case that need not be proven, and I can take notice of that. We can also take notice of adjudicative facts that are matters of common knowledge. The example I have here, I don't need an astronomer to testify that it's dark at midnight. Sometimes I'll take judicial notice of geography. I can take notice of the fact that the HASP location on 8th Street is located in the city of Holland, Ottawa County, because it's something that could easily be determined, and therefore I can just take notice of it. So when we're talking about evidence that's admitted in court, we're talking about relevancy. And evidence is admissible if it's relevant, and it's defined in the rules of evidence as any proof having a tendency to make the existence of any fact that is of consequence in the case more or less probable than it would be without the evidence. So that's what we start with, is the idea that the proof that's being offered must be relevant. They say the word that's used is probative. It has to be something that would make a jury or a judge believe an asserted fact is more likely or less likely because of that particular piece of proof. Now, you start with relevant evidence, evidence that's probative, having a tendency to prove or not prove a relevant proposition. But then the relevant evidence goes through filters that the court must consider to determine whether this relevant evidence is going to be admissible evidence. That is, evidence that can be considered by the trier of fact, the judge or the jury, to determine the outcome of the case. And the two general exceptions is that relevant evidence must be admissible under the rules of evidence, the statutes, or the Constitution in order to be considered. And the second part I put there is life is short. Now, when I was a second-year law student at Detroit College of Law, which subsequently became Michigan State University, my evidence professor, A.J. Thomas, delightful old guy. He had an encyclopedic knowledge of not just the law of evidence, but the history of the Detroit court system, and had terrific stories for us. So our very first class, all of us second-year law students have our pens at the ready and to start taking note. And he walks in and says, "Class, I'm going to tell you the secret of the laws of evidence that apply in just about every situation." So we're going, well, this is great, you know. We're going to get it right here at the first class, everything we need to know about the law of evidence. And he goes, and it is this: life is short. Now, we all looked at each other and wondered, what does that have to do with the law of evidence? But he was right about that, and I think I can demonstrate some of that as we go forward today, that the idea that life is short is a consideration when we're talking about the rules of evidence. Now, and I think I've made a presentation at HASP in the past about constitutional aspects affecting the introduction of evidence. And we start with evidence that would otherwise be logically relevant, tending to prove or disprove, would be deemed inadmissible on constitutional grounds, where the way the police obtained the evidence makes that evidence inadmissible. Not because it's irrelevant. In most cases, it's highly relevant. But if the evidence was either seized as a result of a warrantless seizure that's not subject to an exception, or if the evidence was consisting perhaps of a confession that was given by a defendant without the defendant being properly advised of their Miranda rights, that evidence would be excluded on motion of the defendant because of the violation of the constitutional rights. And the idea behind that, and it's a controversial idea, but the idea behind the exclusion of evidence that was unconstitutionally obtained is that the courts have, for the last half century, basically agreed that the only good way to deter the illegal police conduct is to render the results of that illegal conduct inadmissible in court. And again, it's the idea of letting the defendant go on a technicality. Well, the U.S. Constitution, I don't think, is a technicality, but they've not found a better way to address those sorts of violations, unlawful police conduct. There's also a concept called the fruit of the poisonous tree, which means if you've obtained evidence, let me shut my phone off here a second. If you've obtained evidence that through an unconstitutional search or seizure, and that leads you to other evidence then that other evidence is also inadmissible as the fruit of the poisonous tree is the concept. There are exceptions to that. For example, I had a motion hearing just a couple weeks ago, and the behavior by the police officer was really quite innocent. He had stopped a motorist. It was a valid traffic stop. He had discovered that the motorist was driving without a valid operator's license. So he placed him under arrest. And all of their encounters had been going on outside the vehicle. But once he got the defendant inside the vehicle, he smelled alcohol and said, "Have you been drinking?" Now, when he said that, the defendant was already under arrest. That is, he was in police custody, so Miranda would apply. And this was a question that he asked without previously giving him his Miranda rights. So when the yes answer to that question led to other evidence, the administration of field sobriety tests, a blood test, other observations, and a charge of operating while intoxicated, in addition to the charge of driving with license suspended, the defense attorney brought the motion and said, "Judge, look, the question that he asked that led to all of this, have you been drinking, was a Miranda violation because he hadn't previously advised him of his Miranda rights and he was under arrest. And I'm asking you not just to suppress that statement, but also all the subsequent evidence that was obtained under the principle of the fruit of the poisonous tree." Now, I denied his motion, except for the actual question and answer, which I ruled in as inadmissible, but the prosecutor really didn't need that. But there's what's called attenuation involving inevitable discovery or an independent source. And I rested my decision on the idea of an independent source, meaning that, well, yeah, the police officer asked the question. He should have advised him of his Miranda rights ahead of time. He didn't, but that all of that evidence that was obtained would have been obtained or was obtained from an independent source. That is, when they got him back to the station, another police officer smelled the alcohol, ran him through the field sobriety tests, had him submit to a blood test, so that there were intervening factors that would allow that constitutional violation to go away and not throw the whole case out. So that's sort of how that works. Now, there's also constitutional law that says even an inadmissible statement, because it was given as a result of, in many cases, failure to advise Miranda rights or deemed otherwise an involuntary statement, even if it can't be used by the prosecutor in their case in chief, meaning the officer can't testify and then he confessed to the offense at the time that they're beginning the case. If the defendant is foolish enough to take the stand, and you have to remember that a defendant cannot be compelled to testify in their case. Prosecutor can't call him as a witness. Defendant has the absolute right to remain silent. Prosecutor can't comment on the defendant's exercise of the right to remain silent, meaning that he can't talk to the jury and say, well, if the guy didn't do it, he would have gotten up and testified. But if the defendant were foolish enough to actually testify in the case, then that confession, even though it was unconstitutionally obtained, can still be used to impeach. And when we're talking about impeachment in a case, and we'll cover it more in just a few minutes, meaning discredit that person's testimony. So it can be used to, if the defendant's on the stand saying, I didn't do it, the fact that he confessed to saying that he did do it could still be used to impeach that testimony. So a jury is given what's really a worthless limiting instruction saying, okay, now you can use his confession to judge his credibility, but you can't use his confession to judge whether he did it or not. I'm not sure a jury is able to make that distinction, even though the law does. And the other constitutional aspect of the law of evidence is a curveball that was thrown at us, about 10 or 15 years ago. And we'll talk about this in a few minutes about hearsay statements that might otherwise be admissible hearsay as an exception to the hearsay rule, might still be inadmissible as a violation of criminal defendant's rights under the Sixth Amendment's Confrontation Clause. Now, that's not based on wrongful police conduct, and I should mention that when we're talking on the attenuation theory that I was talking about above, the seriousness or egregiousness of the police conduct comes into play. That's one of the reasons I decided against the defendant in this case, because the police officer's conduct, I think he was just sort of startled when he got him into the police group and says, "Oh, have you been drinking?" And I just didn't see that as more than a technical violation, that it was not egregious. But Confrontation Clause issues, again, are not based on the wrongfulness of the police behavior or activity, but it's involves trying to admit a statement by someone who's not in court that would otherwise be admissible hearsay. But this U.S. Supreme Court threw us this curveball and says, no, you still can't put it in because the defendant has the constitutional right to confront and cross-examine his accusers, and by getting this statement in, you're violating his right to confrontation. It's complicated. It's complicated to the lawyers and the judges. It's a developing area of law, and I'll just touch on it briefly a little later, but it's hard to spot, and it's hard to explain, and it's hard to follow. But it's new law that's been thrown at us, and we've got to follow it. So in addition to, again, relevant evidence that might have a tendency to prove or disprove a fact and issue, relevant evidence can also be admissible on statutory grounds, meaning that the legislature has passed something. I touched on this earlier. Things like the rape shield laws forbidding the questioning of a rape victim as to oops, I'm heading the wrong way here. Rape victims cannot be questioned about his or her past sexual activity with anyone other than the defendant if consent is an issue. Also, the law of privilege is entirely based on what the legislature has recognized as certain communications between people in a certain type of relationship that would not be admissible in court. And I think only attorney-client privilege is still common law. The rest is statutory, attorney-client privilege, physician, social worker, or psychologist privilege with respect to a patient, clergy, penitent, reporter source, teacher, students, that is, student who is given a statement to a teacher or counselor and in confidence has the right to expect that that statement will be confidential. Now, there are multiple exceptions or limitations on that general rule of privilege, which says that communications can't occur between people, communications that occur between people in these relationships would not be evidence at trial. There's also the spousal privilege. That is, generally speaking, one spouse cannot be compelled to testify as to statements that the other spouse made to them. except in certain circumstances. Obviously, the victim in a domestic violence case can testify to anything the alleged perpetrator might have done, but it involves both a testimonial and communication privilege, so that if the spouse is aware of conduct by the defendant, he or she may not be compelled to testify as to what she observed. That's sort of the wait till we get home type of rule, where you don't want to pressure a spouse into revealing these sort of things. And all of these recognize policy considerations that want to keep this relationship a healthy, trusting relationship, whether it's spousal or whether it's the professional relationships. It's not based on the relevancy. The evidence could be extremely relevant, but it's a public policy recognition that these relationships are so important that we're going to make sure that the law of evidence doesn't limit people from fully disclosing what they need to disclose, and be able to rest assured that that information is going to be confidential. So, took a while to introduce it, but we get to the point of what I'm talking about here today. Relevant evidence, to recap, can be admissible, or it could be inadmissible for constitutional considerations, or it can be inadmissible because the legislature has said it would be inadmissible, for the examples I gave. And then we get to the rules of evidence, which provides its own set of filters regarding the admissibility of evidence. So that, under the rules of evidence, again, we still need to consider that evidence that might be, again, the word is probative, that is logically relevant, tends to prove or disprove, might still be inadmissible under the rules of evidence. And the notes I make in the parentheses are the MRE, the Michigan Rule of Evidence, that applies to that particular proposition. So a judge may need to consider whether the evidence is more prejudicial than probative. In other words, this is going to have a negative impact on the jury's ability to decide the case because of the evidence, while marginally relevant, is inflammatory or prejudicial. Probably the best example that I can give is, and the worst part of my job, is autopsy photos or crime scene photos, where it is gory and gruesome, and it's hard to unsee a photograph like that. I know that I will spend the rest of my life being able to recall the autopsy photos for the young lady who was raped and murdered at the Blue Mill Hotel back in the late 70s, when that cold case finally came to light. So the court has some discretion to say, okay, prosecutor, you can prove your case, get in the photos that you need to get in, but let's keep the gore to the minimum, because it's going to have an adverse impact on what the jury wants to do. For the same reason, evidence that might be confusing or misleading can be excluded, even if it is perhaps marginally probative or logically relevant, or by considerations of undue delay, waste of time, or needlessly cumulative. And this is probably the most stark example of the life is short idea. I don't need to have 5 witnesses to the same event all testify to that same event. At some point, it becomes needlessly cumulative. again, the prosecutor or the plaintiff or whoever has the right to put in their case, but at some point it just becomes unnecessary. It's needlessly cumulative. Sometimes in the middle of the trial, the parties will ask for an adjournment or a continuance because they need to come up with some bit of evidence that they don't have available. Normally, I'm going to deny that because of the delay that's involved or the waste of time. So under the rules of evidence, then, even if it tends to prove or disprove, if what it tends, the weight that it has on that end has to be balanced against the weight of it being prejudicial, confusing, misleading, or just a waste of time. So that's sort of the beginning point under the rules of evidence with consideration whether to admit the evidence. Now, sometimes relevant evidence is inadmissible under the rules of evidence. Again, not because it's not probative or not because it's unreliable, but there are instances where, again, as a matter of public policy, this evidence is going to be inadmissible in court because the conduct that that evidence is trying to show is conduct that we would, in most cases, encourage. Probably the leading candidate in that area are what are called subsequent remedial measures. If a guy got his arm crushed in a machine at work and the owner of the business put in some new safety feature so the next guy wouldn't get his arm crushed, the fact that he did that could not be admitted into evidence to prove that they were negligent in the first place for not having the safety device installed. Public policy behind that is obviously that you would rather have one crushed arm rather than two crushed arms. So you want to encourage people to make these subsequent fixes or repairs or remedial measures, and you don't want them to sit there and think, well, gosh, if I do that, it's going to be used against me in court, so we'll just not put any fence or guard on that industrial press, even though it runs the risk of someone else getting injured by it. So remedial measures taken after the fact are not admitted into evidence. Settlement offers aren't admitted into evidence. In other words, if you're, the fact that to try to avoid going to court, you're offering to pay the plaintiff $100,000 to settle the case, can't be admitted into the courtroom proceedings because, number one, we encourage settlement of the cases. We would just as soon see the cases settled, and a party would be disinclined to offer any sort of settlement if they thought it would be used against them in court by the lawyer for the other side arguing, well, they wouldn't be offering to settle the case if they didn't think that they were liable. And same idea, payment of medical expenses implies an acknowledgement that they were responsible for somebody's medical expenses, but we would like to see the people pay those medical expenses if they can. So again, not admissible for public policy reasons. Plea negotiations are sort of the criminal law equivalent of the settlement offers. If a defendant's offering to plead guilty to a 4-year larceny in a building charge to see a 15-year home invasion charge go away, that be brought up if the case doesn't settle and goes to trial on the home invasion charge, because again, you want to encourage negotiations and settlement of these cases. And the existence of liability insurance is also inadmissible, probably because the insurance companies don't want you to know that. So if you've got an automobile negligence case and the defendant has has liability insurance, or the employer has insurance to cover that crushed arm in the drill press, juries tend to write bigger checks for the plaintiff if they know that it's not the defendant's money, that it's insurance money. And so the fact that a defendant or plaintiff might have liability insurance that covers the matter, and in almost all cases they do. In an automobile negligence case, the lawyer for the defendant is probably the lawyer hired by the insurance company to defend that person, but the jury doesn't know that. At least they're not told that in the course of the trial. So again, relevant, probative evidence, inadmissible, not because it's not relevant, not because it's not probative, but because public policy says that there are greater concerns that supersede the use of that evidence in trial. So here's where we get into the actual presentation of evidence at trial. And the normal method of presentation of evidence involves the plaintiff in a civil case or the people in a criminal case calling their witnesses first. After they have presented all of their witnesses or evidence, the defense calls their witnesses. And then after the defense calls their witnesses, if any, the people then have the right to offer what's called rebuttal testimony to respond to any issues raised by the defense that weren't raised in the original part of the presentation by the people. And a witness called is questioned first by the party calling that witness. It's called direct examination. A witness is then questioned by the other party when the direct examination ends. That's cross-examination. And the process can actually, it's sort of a tennis match where it can go back and forth 6 or 7 times depending on what's being brought up or not being brought up. So you can have redirect or recross, or I suppose they call it redirect and recross if it keeps on occurring. But the witnesses are testifying, that is, they are answering questions asked by the lawyer. Sometimes it's hard to get the witnesses to answer the questions asked by the lawyer. They'd rather say what they want to say rather than respond directly to the question. So that's something the court has to control and just say, respond to the question and then wait for the next question, because they usually want to editorialize or further explain their question. So that's a measure of control that we exercise there. Also in the course of a trial, I don't do it often, judges in general don't do it often, but a judge may also ask questions of a witness to cover areas that might not have been fully covered in the original examination. I and most other judges shy away from that. We're required to give an instruction to the jury that makes sure that they understand that the fact that we asked questions of a witness is not us tipping our hands as to whether we think that, that we're favoring one side or the other, that we're just trying to cover areas that weren't covered. And I can tell you as a former lawyer that I hated it when the judge asked questions of a witness, because if I wanted the answer to the question, I would have asked it. And if the other side's not asking the question, I really don't want the judge to jump in. I would rather that the evidence didn't come in. But be that as it may, a judge may ask questions of the witness. And a recent development over the last few years, at least in the state of Michigan, jurors are also allowed to ask questions of the witnesses. It's not something I'm crazy about just because it's sort of a clunky procedure that involves after after the witness testifies, I ask the jury, does anyone on the jury have any questions? If they do, write the questions out, hand it to the bailiff, and then the bailiff receives that written question. I review it, determine whether it's a question that should be asked, and if it is, then I'll ask the question. If I determine that it shouldn't be asked, then I won't, but then the jury doesn't know exactly why the question wasn't asked. But again, it relates to the rules of evidence. So in addition to the attorneys asking, the judge can ask, and now juries may also ask questions of a witness. Now, obviously, the goal of a party calling a witness is to elicit favorable testimony, and the purpose of the other side is to discredit that testimony. And the process of discrediting a witness's testimony is called impeachment. It has nothing to do with removing an elected official from office. Don't know why they call it impeachment, but that's what it's called. And the process of attacking witness testimony involves several different techniques to try to establish either that the witness's recollection of the events is faulty or he or she is deliberately lying. And questions may be asked of a witness to try to establish that the jury should give their testimony less weight. Probably, witness bias. If a friend of the defendant is testifying, the jury has a right to know that the person who's testifying is a friend of the defendant, and that witness may have a personal interest in the outcome. It's witness bias. And certainly all sorts of questions can be asked regarding the particular incident that the witness is an eyewitness about, as to their ability to see or hear accurately exactly what they're testifying to. Witnesses may be asked about whether they had prior coaching about how they would testify. Had the witness been drinking or using drugs that might have impacted on their ability to recall? Those are all fair game and fair questions to be asked by the other side to try to impeach the testimony of a witness. Now, often you have police witnesses who will come to testify to an event that took place 3 or 4 months ago, and their recollection of the events is obviously diminished by the passage of time, that they've had several other similar incidents since then. And in almost all cases, the police have prepared a police report near the time that the incident occurred, usually right afterwards, so that that's sort of legal coaching. That is, you can, if the witness testifies, and it doesn't have to be a police witness, it can be any witness, that says, I don't recall exactly what occurred, so I can't answer your question. They can be asked, well, you've prepared this written memorandum or police report about this incident. If I show it to you, if I show you this, will that help to refresh your recollection? And they can be shown the document, and then the witness will either say, yes, okay, that refreshes my recollection, here's the way it happened. Or they can say, I read this and I know it was written down, but I still don't have an active recollection of exactly how that took place. I assume it's true because I wrote it down that way, but this has not refreshed my recollection, in which case the document can possibly be admitted. I see all these. I finally noticed that we have some chat items here. I'm just going to take a brief look at it. All right, that one was answered. Why does the speaker box keep flipping to another person? Got me on that one. But apparently that was answered too. So I think I've answered all the questions that are up on the chat right now. And my PowerPoint keeps flipping because I keep touching my mouse, which causes it to go forward. I'll try to stop doing that. A witness can be impeached by prior inconsistent statements. That is, if a witness told the police officer something and their testimony is different from what they told the police officer, or if the witness testified at the preliminary examination and then the testimony that they're giving at the trial is different, then obviously the competent attorney is going to say, you know, well, you testified that there were 3 people robbing the store at the preliminary examination, and now you say it was only this one person who was robbing the store. Were you lying then, or are you lying now? What's your explanation for your prior inconsistent statement? That's probably one that's most consistently used as a means of impeaching the testimony of a witness. A witness's prior criminal conviction can be a source of impeachment under limiting circumstances. Generally speaking, the conviction has to be less than 10 years old, has to involve an element of dishonesty, embezzlement, false pretenses, something like that, or it can involve theft if it's a serious enough theft offense. And again, the idea is, particularly if it's a defendant, is not to convict based on the prior incidents, but only to give the jury information that helps them assess the credibility of the witness. The theory being that if a person has been involved in dishonest behavior in the past, resulting in a criminal conviction, that may help them determine how believable or credible that witness is in this particular case. But it's based again on the prior convictions, is again looking at credibility of the witness. And this is very rare, but it's in the court rules of evidence that a person can testify as to a person's community reputation for honesty or dishonesty. So it's about the reputation in general. In other words, you know Frank Smith, you know Frank Smith's reputation in the community, Mr. Witness. What is his reputation in the community for honesty or dishonesty? And the witness can say, you know, he's a used car salesman. I hope none of the people here are used car salesmen, but he's a used car salesman, and you hear a lot of complaints about him, and generally he's not well regarded in the community as far as being honest or dishonest. I'm trying to think of an instance where I had that sort of impeachment, and I can't think of one right now. So that's relatively rare. But those are various means that can be used to impeach a witness. That is, to try to convince the trier of fact, judge, or jury that they should give this witness's testimony less weight in deciding the facts of the case. Now, vouching for a witness is sort of the reverse of the coin, asking somebody how truthful that witness is. And generally speaking, a witness in a trial cannot vouch for the credibility of another witness at the trial. That determination of the credibility of a witness is solely at the discretion of the trier of fact, the judge, or the jury. Now, a couple of examples, and these are probably 2 or 3 year old decisions that came out of Allegan County prosecutions for criminal sexual conduct involving a minor child, which made it up to the Michigan Supreme Court. That's what the MSC is. And in one of the cases, some sort of psychologist or professional testified that 92% of children reporting a sexual act are telling the truth, based on whatever research he was basing that on. And, excuse me, in the other case, the psychologist testified that the child was probably the victim of a sexual assault, where under these particular circumstances, the only evidence that existed, there was no physical evidence or other corroborating evidence. The only evidence that the child was the victim of a sexual assault was her saying that she was the victim of a sexual assault. So in both of those cases, somewhat surprisingly, Michigan Supreme Court says, these are both examples of one witness vouching for the testimony of another witness, the credibility of another witness, either by saying that she's probably not one of the less than 10% of children who falsely report a sexual act, or she's probably telling you the truth when she says she was the victim of sexual assault. Excuse me. So that's inadmissible testimony, because you can't vouch for the truthfulness of the testimony of another witness. All right, so presentation of evidence. I guess that's why we're here today. The process that I've described of direct and cross-examination is tricky. Questions can be in an improper form, and this can be annoying. When you're cross-examining a witness, you can ask him leading questions. A leading question usually starts with the words, "Isn't it true that?" It's a question that suggests the correct answer to a question. You can lead a witness that you are cross-examining. You may not lead a witness if that is your witness that you are conducting the direct examination on. There's an exception where your witness turns hostile on you, but generally speaking, an objection is proper when you say objection, leading the witness. Sometimes it's always a valid objection. Sometimes it's an annoying objection because the other side is just trying to get through a body of evidence that's not critical to the case, but trying to do it in an expeditious fashion. But it's easy enough to change a leading question to a non-leading question. I'll even sometimes say, rather than saying, isn't it true that you are employed by the Holland Department of Public Safety? Objection, Your Honor, it's leading. Well, yes, it is leading, but sit down. You direct the attorney, say, why don't you ask him whether or not he or she is employed by the Holland Department of Public Safety? It's easy to get around leading questions. Questions can be improper in that it's causing or calling for witness speculation, particularly if you've got a non-expert witness asking the witness to offer testimony about what might happen under a given circumstance or hypothetical, requiring them to speculate about what might have happened. Do you think she stayed at the hotel room, or did she leave at some time where the witness doesn't know? You know whether she stayed or left. It's asking the witness to speculate as to whether she stayed or not. Those sorts of improper form questions. Most of the objections that we deal with probably involve lack of foundation for testimony. In other words, certain questions can only be asked if a proper foundation can be, if preliminary questions are asked and answered by the witness, that allows the witness to answer the question that the attorney is trying to get at. Good example is something as simple as a speeding ticket. Now, some of you may be old enough to remember a guy by the name of Zoltan Ferenczi, who was an unsuccessful candidate for governor, but had some statewide offices. He was sort of a political gadfly, but there's a couple of interesting cases among the Court of Appeals opinions that involve him, and one of them involved Zoltan getting a speeding ticket while he was traveling somewhere in the Upper Peninsula, but it developed the area of law as to sort of foundation that needs to be laid even for something as simple as a speeding ticket. The prosecuting attorney can't just say to the police officer, so was the defendant going 85 in a 70-mile-an-hour zone? If that's the first question, defendant or defense attorney is going to say, objection, Your Honor, lack of foundation. Because the police officer has to testify that he observed the vehicle, that prior to going on his shift, he tested the radar unit in his vehicle, that particular radar unit is properly certified by the agency that certifies the units, that if the officer's vehicle was also moving, the officer has to testify that he double-checked that his vehicle's speed was the same speed that his radar unit was measuring for the officer's vehicle. So all of those questions are preliminary foundation facts, and sometimes the attorneys tend to skip that and get to the meat. The same thing happens with breathalyzer. Breathalyzer, it has to be shown that the person who operated the breathalyzer knows how to operate a breathalyzer. It has to be shown that the breathalyzer was properly calibrated and periodically checked by the people who do the checking, and that the proper observation period was involved, proper administration of the test. These are all preliminary or foundational questions that have to be asked before I can allow testimony to come in as to what the breathalyzer results are. Okay, here we got one. A couple of great questions. First of all, how broad do arrest charges have to be made to be covered under the Miranda law? The Miranda law is based on custody. If a person is in custody, they have to be advised of their right to not say anything or to speak with an attorney before they say anything. So custody is sort of a fluid concept. The idea is that you are not free to leave. If you're in handcuffs in the back of a police car, you're in custody, even though you haven't been transported to the jail yet. If you've been called down to the police station for questioning by the detectives in a certain matter, you're not in custody, even if you're at the police station, if you're free to leave. And frequently the police will say that when the person first walks into the interview room. You're free to go if you want to. So then they don't have to advise them of their Miranda rights. So Miranda is about making a voluntary statement that has to be a knowing statement in response to a question offered to them. And the linchpin there, like I say, is the person has to be in custody. Once they're in custody, they need to be advised of their right to remain silent. Now, next question. Is a minor child considered a credible witness on his or her own then in cases like you described in Allegan County? Yes and no. All right. One of the other rules of evidence is that a person has to be a competent witness. That is, they're placed under oath and they have to have some idea of the gravity of the situation so that the oath means something to them. So with a child witness, you, if they're going to testify, you have to investigate how much they understand the, number one, the difference between telling a truth and telling a lie or a fantasy. And number two, that they understand how important it is that the testimony that they give in court will be only the truth. So typically, either the judge or the prosecutor will ask the person, you know, if I said I was wearing a red tie today, would that be true or not true? And the child will say, well, that's not true. You're wearing a yellow tie or a maize tie, as the case may be. So you try to establish that they understand the difference between what's fact, what's fantasy, and then to understand that this is important, that they only say what they know to be true. And that's if the court is satisfied then, and obviously it depends on the physical age and maturity of the witness and the response to those sort of preliminary questions, then the court has to make a determination whether that child is a competent witness. Credibility is up to the trier of fact, but if I'm going to allow that child to testify, I have to have some idea that they understand how important it is that they only testify truthfully. I think I'm caught up. All right, so you got the foundational questions. Sometimes it involves questions that were asked and answered. Oops, wrong direction here. Sometimes the lawyers are so busy thinking about the questions that they are going to ask that they don't listen to the questions and answers being asked by the other side, which makes them a poor attorney, because the real meat of a case is your ability to seize on those questions that are being asked of the witness. So frequently the attorney will get up and ask the same question that was asked by the other attorney in the other matter, and that's proper objection, Your Honor, asked and answered. Sometimes it's a matter of trial strategy, where the attorney wants to ask the questions as many times as they can get away with, because it's a critical question and they just want to keep hammering on the answer to that question. Sometimes the attorneys will ask the same question over and over again, hoping that they get a different answer on one of them, but it's objectionable that because the question's already been asked or answered. Sometimes the question will assume facts not already testified to. That's objectionable, but I'll sometimes take those objections under advisement, meaning I won't rule on them right away, because I'll give them a chance to put in the questions that they need to ask to get those facts into evidence. All right, so finally we got to the hearsay rule, and that's why you're all here today, to learn about the hearsay rule, I'm sure. Hearsay is generally not admissible. Quick chat question. What determines when a case is decided by a judge or a jury? Everyone has the right to a trial by jury in a criminal case, and in most civil cases, the person starts in a criminal case with the right to a trial by a jury. Prosecutor has the right to a trial by a jury. If the prosecutor and defendant agree to not have a trial by a jury, then it will be a trial before the judge. But it takes an agreement by both sides in a criminal case that it's going to be a jury trial, or that's going to be a judge trial, otherwise it defaults to a jury. The opposite's the case in civil proceedings, where it defaults to a non-jury trial. In a civil case, you must make a written demand that the case be tried before a jury. There's usually a jury fee involved also. So the parties determine whether it's a trial by a judge or a jury. It depends whether it's a civil or criminal case, which one you start with. But it can go either way. And it's not the judge's decision, it's the party's decision. Yeah, I'm trying to get back here. It's not backspacing for me. There we go. So you have the hearsay rule. You hear it all the time. That's hearsay. And it's not admissible. Well, generally that's true. Hearsay is not admissible. What's a hearsay statement? A hearsay statement, or it can be a writing, is a statement made by a person who is not the witness testifying, and that person who's not testifying, called the declarant, is being offered as evidence of its truth. Bill Van Dyke testifies that Rachel Smith told him that she saw the defendant leaving the house shortly after the robbery. All right. Bill Van Dyke is the witness. He's testifying as to what Rachel Smith told him. That's hearsay. It's objectionable. Rachel Smith should be the one testifying as to what she observed, because Rachel Smith should be cross-examined by the defendant regarding the things we talked about earlier, her bias, her ability to see or hear accurately, the sort of things that people get impeached over. And that's why hearsay, generally speaking, is inadmissible, because it does not afford the other party the opportunity to question the declarant, that is the person who's supposed to have said what they said. And all the witness did is hear what they had to say, obviously then being called hearsay. And one of the key factors is it needs to be offered for its truth. I'd like to have a quarter for every time I hear a police officer testify and said, I was dispatched to domestic violence at such and such an address. The dispatcher said, there's a domestic violence at such and such an address, and that's very true. Objection, hearsay, officers testifying to what the dispatcher told him. And yes, it is hearsay, because it's not the dispatcher who's testifying, but it's not legal hearsay, because the officer's only testifying to that to explain why he went to the scene, not for the truth of the fact that there was a domestic violence that occurred there. So, and that sometimes that's hard to parse out. It's sort of a head scratcher where somebody makes a hearsay objection, and I'm trying to figure out, is it being offered for the truth of the statement or being offered for some other reason? And if it's being offered for some other reason than its truth, then I'll admit the statement and instruct the jury that, okay, this statement is admitted not as proof of its content, that is, not for the truth of the statement, but for some other valid reason, like explaining why the police officer was dispatched to that particular address. Now, there are literally dozens of exceptions under the hearsay rules that say, well, yeah, it's hearsay, but it's reliable enough that we're going to allow it. And Admissions, in fact, aren't even considered hearsay. An admission by a party, a confession by a defendant. If somebody testifies that the defendant, like a police officer, testified the defendant confessed to committing the offense, that's not hearsay. And assuming that Miranda had applied or Miranda had been waived by the defendant, that's going to be admitted into evidence, even though it's the officer testifying as to what the defendant told him, and it's being offered for his truth. It's one of the recognized exceptions. Another form of that is what's called a statement against interest, something that a person would say that's so much against their personal interest that they wouldn't lie about it. It must be true. Some of the more common exceptions to the hearsay rule are what are called excited utterances. And again, the idea is that the circumstances of the statement being made are such that the person who made the statement wouldn't be in a position to fabricate it. Now, a great professor named Irving Younger once said, all excited utterances begin with the words, "Oh my God," and then describing some incident or event. That's the sort of thing that would be admissible because there's no time to fabricate. It comes up often in domestic violence cases where the police come to the scene and a very upset person is describing, being the victim of an assault or something like that. And because it's not the victim testifying, it's hearsay. But if the prosecutor can show through sufficient foundation evidence, how close was this statement made to the time of the incident that they're talking about? What was the person's mental state or condition at the time? Then that will come in under the excited utterance exception to the hearsay rule. So the officer will be able to testify that that's what the victim said at or about that time. More on that in a minute when we get to confrontation clause. Business records, business records or records regularly kept of any organization. It may be someone else who keeps those records, but if a witness can testify that says, these are our records that show some sort of activity that we do, those written records, ledger accounts for somebody who owes money or something like that, that'll come in under the hearsay exception, even if the person who's there as a witness isn't the person who filled out those records or typed in the data. They'll say, yeah, this is the way we keep our records. This is what we do in the regular course of our business. So therefore, these records have some indication of reliability. And a child's statement of a sexual act made in close proximity to that act will again also be admissible as a hearsay exception under the rule of evidence. So if the child tells their mother or teacher or something close to the event that as to what happened, that family member or teacher will be able to testify as to that child's statement so as to negate any recent fabrication of the child. And proximity in time can be extended where there's fear or threat on behalf of the child that causes them, as is usually the case, to delay some significant period of time before they actually make a statement about what happened. So those are the sorts of hearsay questions that we deal with, and just a few of the dozens of exceptions. Now, when you talk about the hearsay rule, Supreme Court threw a curveball at us with the case of Crawford versus Washington, and said that evidence that would otherwise be admissible as a hearsay exception like an excited utterance, would not be admitted if it violates a defendant's right to confront his accuser under the Sixth Amendment. And the test they talk about is testimonial or non-testimonial. Best example I can give is, all right, you have your police contact with the victim, and she is in this agitated state that would otherwise allow this statement to come in as an excited utterance. If the questions that the officer are asking are geared primarily toward preparing for the trial of that defendant, it's going to be a violation of the Confrontation Clause. Whereas if it's not related to that, like if the person's still at large, if he's still a threat to the person, then he's asking him those questions to try to apprehend the person rather than trying to convict the person. It's confusing. It's hard to make the correct call on that. There's a Michigan case a couple years ago. One of the surest or most reliable forms of an exception to the hearsay rule is what's called the dying declaration. You know, the cop walks over and says, "Hey, Clancy, you're not going to make it. Tell us who did this." And, you know, Clancy will say, if I'm doing a film noir movie, it was Joey the stool pigeon or whatever. Normally, a dying declaration by this person, the fact that they died makes them unavailable to testify. The police want to be able to say, you know, Clancy said that it was Jimmy the stool pigeon who did it just before he died. What's more reliable than a dying declaration? If you know you're dying, chances are you're not going to be lying to get someone in trouble. At least that's the theory. But now the Crawford case says, you know, if you're asking that question primarily for preparing for trial rather than trying to apprehend Jimmy the stool pigeon, then it's going to be inadmissible as a violation of the Confrontation Clause. A lot of cases have come down the line in a short period of time on that, and I'm glad I don't have to deal with it very often because it's very complicated. Excuse me. I'll wrap up here with a couple of notes about expert witnesses, because we deal with expert witnesses all the time. And special rules apply to expert witnesses where the court has to make a determination whether the expert witness can or should testify. And it's based on if the expert's testimony would be helpful to the trier of fact, whether it's a judge or a jury. Now, I'm in the middle of a contract case involving whether or not the purchaser of certain property violated the terms of the contract requiring them to maintain the property, which involves blueberry and cranberry fields. And I've taken a day and a half's worth of testimony from expert witnesses on the proper procedures to be used in fertilizing, draining, harvesting, weeding blueberries and cranberries. And those are expert witnesses. We had an expert witness, a PhD, a guy who has a PhD in cranberries. And I said afterwards, I hope that sometime in my life I can get as excited about anything that I deal with as this guy was about cranberries. But he was a good expert. He was very knowledgeable in the area. And we have to decide that to allow expert testimony, the expert knows what he's talking about or she's talking about. And the area of expertise is good science. There's a case called the Daubert case where you have to have a Daubert hearing to determine whether this area of expertise is a reliable area before you can allow the expert testimony in. So things like DNA more recently, or fingerprints for the last century, That's good science, and experts on fingerprints can testify to that. Not a polygraph. Polygraph has never been deemed to be sufficiently reliable to have the results admitted into court. They're still pretty handy. I read in the news yesterday that someone was convicted of espionage because they were working for the government, required to take routine polygraph tests, and they failed polygraph, prompted an investigation and eventual conviction. So certain areas of science are reliable, others are less reliable, and it's up to the judge to decide whether that particular area of science and that particular person who's going to testify about that area of science are both reliable before it will be admitted as expert testimony. Oops, I guess we're at the end. I do have one chat here. In your opinion, what movie or TV show most accurately depicts the trial process you have described today? You know, you don't want to watch a TV show or movie with me that involves courtroom techniques, because I'm shouting objection at the screen or something like that. You know, Law and Order isn't bad, but it's not good. Actually, the original old black and white Perry Mason shows, notwithstanding my earlier disparaging comments about the judge who was always on Perry Mason's side, are as good as good a presentation of the laws of evidence as any that I've encountered. Many of the Grisham novels and the movies that were made are more or less accurate, but obviously if it's a question of the rules of drama or the rules of evidence, the rules of drama are going to win. And let's see, how can a lawyer in good conscience defend someone they know is guilty? It's your commitment to the legal system, because the one thing a lawyer who defends a person who has told the lawyer that they committed the offense. Now remember that I earlier said that that is a confidential statement. It is told in confidence. And the lawyer cannot disclose that statement. But unless they have that situation, which is a relatively rare situation. Generally, a guilty defendant will not tell his lawyer that he or she is a guilty defendant. And it's the defense attorney's job to make sure that the rules of the criminal justice system are followed, the rules of evidence, constitutional laws, because our legal system says it's a matter of a presumption of innocence and proof beyond a reasonable doubt. And we would not have a good system of justice if we decided ahead of time who the worthy defendants were, in terms of do they appear to be very guilty, or are they maybe guilty? Who's going to decide who's worthy of being represented? So most attorneys who do defense work find that what they're doing is a valuable contribution to the criminal justice system. I know I did the years that I was involved in it, and take some satisfaction in a job well done. That's not to say that they don't have a high degree of empathy for a victim, but their job is not to deal with the victim. That's the prosecutor's job. The theory is that if the prosecutor does his or her job and the defendant does his or her job, that the truth will come out. Oh, there's a good one. Traffic light camera. And somebody knew it was Zoltan Ferenczi. Great. He spoke one night at a bar association function. Fascinating man, delightful. I enjoyed him. Yeah, the witness is the camera. How can that witness be cross-examined? Not very easily. I don't like camera traffic lights. But again, you can have a police officer from the traffic division testify, okay, where's this camera located? How does it work? And that sort of foundational evidence. Now this shows a picture of a vehicle going through that intersection. Why did that stoplight take the picture? Well, because that camera is activated if a vehicle enters the intersection after the light is turned red. Okay, and what does that picture depict? Well, it shows a 2015 Chrysler with Michigan license plate, blah, blah, blah. And who is that vehicle registered to? Well, it's registered to the defendant, Mr. Smith. Okay, and then Mr. Smith can testify that it's my car, but I wasn't driving, and then it's up to the trier of fact to decide what actually happened. But there doesn't need to be an eyewitness to convict. Evidence can consist of eyewitness testimony, or it can consist of circumstantial evidence. Circumstantial evidence is every bit as valid as direct evidence that a person saw or heard. It's just that the example they usually use is footprints in the snow are circumstantial evidence that a person had walked there recently after a snowfall. Yeah, so nobody saw the person, but they saw their footprints. And lo and behold, the footprints matched the boots that the person who was subsequently arrested was wearing. Merely circumstantial, but could be enough to convict. Let's see. I think I've answered all of the chat questions, and I think I've run out of time, but I'd be happy to answer any more questions if anyone has anything. So my voice seems to be failing on me here. So I guess I'll turn it back to, oh, here we go. Are you influenced if a defendant did make a generous settlement offer pretrial and it was refused? I'm only influenced, I mean, if you're saying, as the trier of fact, I don't know about it, okay? The jury doesn't know about it. There are ways of doing it. There are what are called offers of judgment that say, look, we'll settle this case for $15,000. And the offer of judgment then, if it's rejected by the other party and they go to trial and don't do as well as what was offered as a settlement in the offer of judgment, the that rejecting side has to pay the attorney fees of the side that made the offer. So it's very helpful settlement technique. Same thing is used by courts in what are called case evaluations, where a 3-lawyer panel says this case is worth $100,000. If the parties accept that evaluation, great. If one party accepts, the other rejects, the other party that rejected better do well at trial, because otherwise they're going to get stuck with the other side's attorney fees that in certain circumstances will involve more money than the amount of money that they were fighting over.
Judge, I have a question for you.
Yes, sir.
It involves expert testimony.
Mm-hmm.
And I have heard and seen several cases in which the judge failed to accept expert testimony that was based upon valid science, based upon peer review literature, but the judge would not accept it. How do we use expert testimony if the judge is going to throw it out?
Well, that's a good question. I mean, there are rules in place, and I referred to the Daubert rules, which were placed in the past. It was the use of expert testimony was based on its general acceptance in the scientific community, and the rules are somewhat different now based on the reliability of the science or the expertise, and obviously, I can't answer the question as to why the judge did that, because if it was deemed or determined to be reliable science, and that the person who's offering the expert testimony, not only that science is reliable and the expert or witness is reliable, he should have accepted the testimony if it was otherwise relevant to the case that's involved. So I don't know why he did it or she did it. That's why we have appeals courts. When I was sworn in as a judge, Judge Ed Post, my good friend, put his arm around me and said, "Just remember, Brad, there's nothing you can do that I can't properly overturn." So,
Well, what I'm speaking about is, science is based upon statistical evidence. If I say that it's 95% fact,
mhm.
and the judge comes out and says, "Well, that's not 100%. I won't accept it."
Well,
To me,
science,
that suggests the judge is making decisions on science for which he's not, or he or she is not,
well,
should be doing.
science has no absolutes. Everything is true until it's proven otherwise. So nothing can ever be 100%. It has to be reliable science. Got one on the chat here. Thank you. My son is a first-year law student. Congratulations to you. Now I understand him better when he tells us about his coursework. Oh, that's great. Best of luck to him.
Well, it's about 5 minutes after, and so it is time to wrap the class. If somebody has a last-minute comment or question, unmute yourself now. Otherwise, thank you so much, Judge Canal, and we appreciate just your contribution to HASP so much. Very interesting.
Well, thank you.
Thank you. Very nice
so
class.
grateful
Thank you, Judge Canal.
I'm so grateful that HASP exists in our community. It's one of the really great parts.
Thank you.
We're glad for presenters like yourself. Now, this is the last one for the semester
Yes.
for you, Judge?
Yes.
Okay.
That's the last one.
Well, then hopefully we will see you in the spring.
I hope so too.
Yeah, well, thank you so much. Everybody have a great day, and we'll see you soon.
Thank you.
Thank you.
Thank you.